Biden's student loans giveaway is now reversed, unconstitutional. Of course, his administration will continue to push this forward and find other ways where they can rip off the American people and give it away to their constituents. But for now, it looks like it has been halted. Reuters shared with us a U.S. judge strikes down the Biden student loan debt relief plan. Here's what they said, written by Nate Damon. Says, on November 10th, a federal judge in Texas on Thursday ruled that President Joe Biden's plan to cancel hundreds of billions of dollars in student loans was unlawful and it must be vacated. Delivered a victory to conservative opponents of the program. The judge is named Mark Pittman. He's an appointee from Donald Trump out of Fort Worth, Texas. We're going to read through the full opinion. It's short, 26 pages. The debt relief plan had been temporarily blocked by the Eighth Circuit Court of Appeals out of St. Louis and others. Big loss for the Biden administration, but very interesting because of the timing. A federal judge orders Biden's student loan program unconstitutional, and very conveniently, this was filed on November 10th, 2022, just a couple days after the midterms. So everybody who went and voted thinking that they were going to be getting a big fat handout from the Biden administration, who went and cast their ballots on November 8th, they all going to wake up with a rude awakening a couple days later when all of that promised government money is no longer available. Here's what the federal judge said. Filed out of Fort Worth Division out of Texas. The order is as follows. Federal judge writes, the Constitution vests all legislative powers in Congress. This power, however, can be delegated to the executive branch. But if the executive branch seeks to use that power to create a law of political significance, it must have clear congressional authorization to do so. In this case, the HEROES Act, a law to provide loan assistance to the military, does not provide Biden and his executive branch a clear congressional authorization to create a $400 billion student loan forgiveness program. Thus, the program is an unconstitutional exercise of Congress's power, and it must be vacated. Now, the judge says the court expresses no opinion on the program itself, whether it needs, we need money to be sort of given out or granted or gifted away. They say that's not for us to consider. It's a consideration that's inappropriate for this court. Our job is merely to interpret the law. That's it. They give us some background. They tell us about the Department of Education. They say, they offer two types of grants. A grant, which is sort of a gift, and they offer a loan. Grants don't have to be repaid, but loans do. And previously, when these loans were extended, there have been attempts to reform them. Today, we've got $1.61 trillion in student loan debt, 43 million borrowers. In 2019, Elizabeth Warren wanted to give away $50,000 in student debt. Others wanted to make different offers, and both bills failed in Congress. But the executive branch has recently explored its ability to do it itself. If Congress can't get this stuff passed, maybe Biden can do it on his own. Trump also thought about this, considered its authority under the HEROES Act to forgive student loans under the pandemic. Speaker Pelosi agreed with the department's conclusion that it lacked that authority. Even Speaker Pelosi said, people think that the president of the United States has the power for debt forgiveness. He does not. He can postpone, he can delay, but he does not have the power to just give it. That has to be accomplished through an act of Congress from Pelosi. However, Biden promised to forgive all undergraduate debt from 2- and 4-year colleges for people earning less than $125,000. After becoming president, he instructed the department to prepare a memo exploring how they could possibly do this. The department did so, but changed its tune, concluding now that the HEROES Act does allow, oh my gosh, we read it wrong. We missed that whole chapter in that bill. The COVID Biden chapter. Oh yeah. So now we have that bill to create loan forgiveness. The next day, the White House announced the president would fulfill his campaign commitment by providing student loan relief to millions of borrowers. They give us some heavy lifting here. The HEROES Act, it does grant the Secretary of Education some power to do certain things as long as it's necessary to ensure objectives are achieved. They have laws that they have to follow. The Secretary of Education, Miguel Cardona, invoked his authority under the HEROES Act, saying that the loans were harmed by COVID. And he granted the permission to do this. Now, people are filing lawsuit. Myra Brown, Alexander Taylor, they both have student loans. This is the judge writing. And they say, we're here with them. They're here. Taylor is ineligible for a full $20,000 in debt relief because she did not get a Pell Grant. Brown loses out on $20,000 of forgiveness. Then they're both losing money. But they couldn't voice their disagreement with the rules because the Biden administration just did this. Now, they're talking about the APA, which is the Administrative Procedure Act. And this is sort of the rules that say how laws are interpreted and implemented. They've got to follow a certain procedure before they just start granting people things or taking things away from people. And in this case, Biden didn't go through this procedure, right? There should be a window where you can ask questions and voice objections before major policy changes. And so the judge is saying here, in this case, these two plaintiffs, they both had student loans. They're not going to get any money back. And Biden just made these changes without following the APA, which says that there has to be a period of time to ask questions. The same day plaintiffs sued, they moved to enjoin this and to stop this from going forward. They tell about the legal standards and about what's appropriate in order for the court to grant them relief. In this case, they say that the defendants didn't have opportunities to be heard. It says that they have standing. Let's see if we can find some good meat and potatoes to this suit. Judicial review. Now, this is where the plaintiffs say the law was violated. The APA, that Administrative Protection Act, says that agencies have to follow substantive rules for notice and comment. Before you just start changing things, you have to give the public an opportunity to be heard. There are substantive requirements. The students say that the secretary lacks the authority to implement these changes, and they're covering different case law for us. There is a lot of technical stuff in this lawsuit that is typically not that interesting. So let's just jump to this conclusion. Federal judge wraps this up for us, says, this case involves the question of whether Congress, through the HEROES Act, gave the Secretary, Miguel Cardona, in the Biden administration, the authority to implement a program that provides debt forgiveness to millions of student loan borrowers. The total around $400 billion, some say much more than that. Now, whether the program constitutes good public policy, the judge says that's not for me to determine. Still, no one can plausibly deny, says the judge, that it is either one of the largest delegations of power to the executive branch or one of the largest exercises of legislative power without congressional authority in the history of the United States. $400 billion. The Biden people are just like, oh, we can, just forgive it all. Judge says, no. In this country, we are not ruled by an all-powerful executive with a pen and a phone. Instead, Texas judge says we are ruled by a constitution that provides for three distinct and independent branches of government. And as President James Madison warned in Federalist 47, the accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. The court is not blind to the current political division in our country, but it is fundamental to the survival of our republic that the separation of powers as outlined in our Constitution be preserved. And having interpreted the HEROES Act, this court holds that it does not provide clear congressional authorization for the program proposed by the secretary. Thus, the student's motion for summary judgment is granted, and the government's motion to dismiss is denied. The court declares unlawful Biden's student loan program, and it is hereby vacated. So ordered this 10th day of November by American hero Judge Mark T. Pittman out of the United States District Court. Amazing. So absolutely true. one branch of government should not be usurping another branch of government. The Biden administration decided on their own that it was appropriate to grant, evidently, $400 billion out of thin air that Congress never contemplated to, evidently, give money to their supporters that they're not ever going to get. Now, as you'll see, this doesn't turn out so well for the students. Thousands of students now going to the federal student aid website, and here's what they see. Welcome to studentaid.gov. Courts have issued orders blocking our student debt relief, and as a result, at this time, we're not accepting applications. Oh, man! We are seeking to overturn those orders. If you've already applied, we'll hold your application. Otherwise, subscribe and check back. We'll post information as soon as further updates are available. Now, obviously, I think they already knew that this was not ever going to pass. It was clearly unconstitutional, but they had some votes that they needed to cram through. And it looks like it may have been successful. After the White House promised millions of student loans, billions going back to evidently students, courts threw it out and the White House responded. Karine Jean-Pierre communicated on November 10th a statement in response to the loss in federal courts. Karine said on behalf of the Biden administration, quote, "We strongly disagree with the district court's ruling on our student debt relief program, and the Department of Justice has filed an appeal. The president and this administration are determined to help working and middle-class Americans get back on their feet by spending a bunch of money we don't have. And while their opponents, backed by extreme Republican special interests, sued to block millions of Americans from getting much-needed relief. For the 26 million borrowers who have already given the Department of Information their information, 16 million people who have already been approved for release, the DOJ will hold on to your information. You're not going to get it. We will never stop fighting for hardworking Americans, no matter how many roadblocks our opponents and special interests try to put in our way." Amazing. So the White House promised people a bunch of ice cream if they behave themselves. They behaved themselves. Now they're not getting their scoops of ice cream. Oh, bummer. Well, that's what the student loan situation looks like. It has been hit from multiple angles, even in a Eighth Circuit Court of Appeals, not looking like the student loan program is going to survive. Of course, we'll continue to cover it if anything changes. Thank you for subscribing and following along wherever it is you're watching this, and I look forward to seeing you on the next one.